It's the parties that will determine the number of arbitrators, 1 or 3. It's the parties that will determine how they are appointed. It's the parties that will determine how the procedure will be carried out. It's the parties that will determine how the award will be written. But if you go to court, you have limited control. It's the court rules that determine all this way. So in arbitration, the only major snag with arbitration is cost. Because it's party driven. It's the parties that pay for the venue, it's the parties that pay the arbitrators. Now, whereas in litigation, it's the state that pays the High Court building, it's the state that pays the court official, it's the state that pays the judicial officer. But in arbitration, the parties pay for this. And therefore, if not properly managed, the costs incurred in arbitration are higher than the costs incurred in litigation. Like the example I just gave, if in 6 months or 1 year you can get a judgment, then you go to court for 6 years, 7 years, you don't have a judgment.
Yes, sir.
And so you find that if arbitration is properly managed and the costs are not prohibitive, for pure commercial disputes, arbitration is preferable to litigation.
Absolutely, sir. I totally agree with you because if we look at it too critically, time is money. So if you can save time, then you can save money. The money that you will spend in an arbitral proceeding, you may think is very high, but if you convert it to the time that you will lose in court proceedings for 6 years, you discover that it's actually cost effective than going through litigation.
The other thing I want to add to that is when you look at our law controlling arbitration, the Arbitration and Concession Act, Section 34 of that law provides that in matters governed by this act, the court cannot intervene unless as provided in the act. Now, and that the parties, when they opt for arbitration, they will agree that the award is final, conclusive, and binding. But unfortunately, in most cases, when the award is published, the losing party will rush to court to attempt to set aside the award under any ground. So, businessmen now see arbitration as a first step towards litigation, and they ask themselves, why do you go for arbitration if you say end up in court? For me, I blame the lawyers, I blame the judges, in the sense that except as provided in the Arbitration and Concession Act, the court should not entertain any frivolous application to set aside an award. And lawyers too, they should ensure that in choosing their arbitrators, they choose competent and qualified arbitrators, so that when an award is written, the award is legal and enforceable. It's enforceable. But when you have an award that is not legal and enforceable, then there's a challenge. So there's a need to ensure that first you appoint qualified and competent arbitrators.
Thank you very much for that profound answer, sir. So we'd like you to let us know what are the various ADR mechanisms or methods of resolving disputes that people can opt for.
In our environment here, we just have negotiation, mediation, conciliation, and arbitration. But in other climes like the US, what we call early neutral evaluation of privilege judging. Early neutral evaluation. When the dispute arises, the parties will engage an experienced lawyer or a retired judge to advise them on the merit and demerits of their cases, so as to know what line of action to pursue. But as I said, in Nigeria, we just have negotiation, mediation, conciliation, arbitration. These are the main ADR processes in Nigeria. Now, what's the difference between them? In negotiation, it's the parties themselves that negotiate. No third party is involved. The parties control the process and the outcome. In mediation, a third party is involved called a mediator. But a mediator decides nothing and awards nothing. A mediator merely assists the parties to arrive at a decision. Now, our friends who are into mediation and conciliation, they will argue that mediation is different from conciliation. But for me, I ask myself, what does a mediator do? What does a conciliator do? Look at the Australian model law, international commercial mediation. It defines mediation to include conciliation. It defines it to mean where you have a third party that assists the parties to arrive at a decision. Now you move that from there to arbitration. In arbitration, in mediation, the parties can control the process, but they don't control the outcome. Now, when you move from there to arbitration, you find that the arbitration gives an award. So in arbitration, the parties control the process, but they do not control the outcome because it's the arbitral tribunal that gives an award. So one major difference between arbitration on the one hand, mediation and conciliation on the other, is that the neutral in arbitration gives an award, whereas the neutral in mediation conciliation does not give an award. The neutral in that regard merely assists the parties to resolve their differences. That's how to categorize it.
Wow, awesome. That's so helpful. So whenever you want to impute or insert a dispute resolution clause in your contract, you know what to do based on this advice. So we'd like to know, sir, we're very curious, what's your arbitration style?
Like I said, it is party-driven. The authority of an arbitrator is derived from the parties' agreement. The parties' agreement, like I said, is party-driven. The principle of party autonomy is the parties that determine the rule of the game. Now, there's also the Act, the Arbitration and Conciliation Act. So, either the agreement of the parties or the Act control the process. So, I try to respect the provisions in the Act and the agreement of the parties, because as an arbitrator, you do not have powers of your own. Your powers are derived from the parties and the statute. So when I'm conducting a hearing, I try to be very, very open. I try to not to impose my views on the parties, because one of the requirements that should give the parties an opportunity to present their cases, and there should be fair hearing. Fair hearing. That's why in arbitration, even if I've concluded the hearing, I will ask the parties, is there anything you want to say? Anything you want to say? So I ensure that the parties are given adequate opportunity to present their cases, and I also ensure that I did a fair hearing.
Fair hearing, that's very critical. It's a natural justice principle that must be upheld by every arbitration practitioner. Thank you very much, sir, for that. So in preparing for an arbitral proceeding, what are the things that the lawyer or counsel and the client should put in place or take note of?
In fact, I wrote a paper called A Counsel in Arbitration. A Counsel in Arbitration. Arbitral proceedings are like court processes. Now, the first thing that a lawyer should do, if there's a contract that has a clause on arbitration and a dispute has arisen within the parameters of that clause, the first thing a lawyer should do, if we are using the Arbitration and Conciliation Act, is to look at Article 3 of the rules which are annexed to the Act. Now, Article 3 tells you what should be contained in a notice of arbitration. Now, if the arbitration is conducted under an institute, what you will find is a request for arbitration. But once the arbitration is ad hoc, you will serve a notice of arbitration. So that notice will tell you what the other side will need to know to ensure that you know that the clause in a contract has been invoked. If proper notice has been given, you should appoint your own arbitrator, depending on what the parties agree, whether it's a sole. If it's a sole, the parties will jointly appoint a sole. But if it's a panel of three, generally, one party will appoint one arbitrator, the other party will appoint an arbitrator, the two will appoint a third who will preside. So as soon as you constitute the arbitral tribunal, the tribunal will call what we call a preliminary meeting. That is the first contact between the parties and the arbitrators and the lawyers. At that meeting, the parties will agree on how the arbitral proceedings will be conducted. For instance, with other pleadings, the claimant will tell you how long to take it to file a plot of claim. The respondent will tell you how long to file the plot of defense, blah, 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 blah. Then the issue of your fees, the issue of applicable rule will come in. After that meeting, you withdraw what we call a procedural order, an order stating what has been agreed at that meeting and how the reference will be conducted. After that meeting, you have what we call a pre-hearing review. At that meeting, at that pre-hearing review, look at the orders that you gave in your procedural order. To what extent have they been complied with? If they are fully complied with, you fix a date for hearing. Now, conducting a hearing in arbitration is similar to conducting a hearing in litigation. So at the hearing, one thing we do that the courts have borrowed from us, that is front loading. In arbitration, at the primary meeting, we tell the parties no oral evidence in chief. No. So when you are filing your pleadings, attach to your pleadings written depositions. That will serve as evidence in chief. So at the hearing, all you do is cross-examination and re-examination. And like I said, it's conducted like in normal court processes until conclusion and all is published.
Wow. Thank you very much, sir. As we round off, I'd like to said something about ad hoc arbitration.
Yeah.
So we'd like you to educate us, sir. What is the difference between ad hoc arbitration and institutional arbitration?
Okay. There are many institutions worldwide conducting arbitration. For instance, we have the London Court of Professional Arbitration. We have the International Centre for the International ICC arbitration. We have in Singapore, we have in Hong Kong, we have in the US. Then even in Nigeria, we have the Regional Centre for International Commercial Arbitration. We have JICAM. Yes. We have ICAM. In Lagos, we have Lagos Court of Arbitration. These are institutions that conduct arbitration. So when an arbitration is conducted under the rules of the center, they are referred to as institutional arbitration. However, where no institution conducts the arbitration, we have the ancestral arbitration rules that are generally used for ad hoc. In other words, the arbitration is not based on the rules of an institution. It's the parties that will agree on the rules. But we find that the ancestral has provided rules that is generally used for ad hoc arbitration. So if you look at our Arbitration and Concession Act, the arbitration rules that are scheduled 1 to that act, they are derived from ancestral arbitration rules.
Wow, thank you very much, sir. So finally, I would like to ask, if a case does not settle at the first arbitration session, what do you advise?
No, arbitration does not have such processes. What happens is, after conducting the hearing, you now publish an award. You now publish an award. In other words, that is your decision. Now, you cannot appeal against an award. All you can do is, if you are dissatisfied, you can apply to court to set aside the award. I repeat, you cannot go to court like a matter is heard in the High Court, you are not happy, go to the Court of Appeal, you are not happy, go to the Supreme Court. It's not so in arbitration. However, once you apply to the High Court to set aside the award, and the High Court maybe refuses to set aside the award, now you go through the normal process. You can now appeal, from the High Court to Court of Appeal to Supreme Court. So that's how it works.
Wow. Thank you so much, Professor Idornigie, for your time thus far. Thank you for speaking to us and educating us. It's been a huge privilege and pleasure listening and learning from you, sir. And to our viewers, we thank you also for watching, for gleaning these insights from our erudite scholar in the house, Professor Idornigie. This is JICAM Arbitration 1.0. JICAM is a fully institutional serviced firm in Abuja, an ADR center with full ad hoc and institutional services. If you would like to have more details about our services and our facilities, kindly visit our website, www.jicam.org. If you would also like to follow us on Facebook, it's JICAM. Follow us on Instagram as well. JICAM is also the username. Thank you so much for watching. We'll see you again.